Resuming debate, the Honourable Member for Edmonton St. Albert.
Thank you very much, Mr. Speaker, and it's certainly an honour for me to rise and speak in favour of Bill C46, the Investigative Powers for the 21st Century Act, which, as you know, Mr. Speaker, aligns with the government's priority of getting tough on crime, including the internet and other computer crimes. It also responds to many of the issues surrounding organised crime. The Justice Committee has undertaken a comprehensive study of organised crime, and at every venue and at every hearing we hear the need for police to have the exact type of tools that C46 provides. So, Mr. Speaker, with the amendments put forward in Bill C46, which amends the Criminal Code, among others, including the Mutual Legal Assistance in Criminal Matters Act and the Competition Act, Parliament will provide police with more precise and less cumbersome investigative techniques which they need and have been asking for in the 21st century to do their work in a more effective and efficient manner. Crime is becoming more sophisticated. Criminals are becoming technocrats, and police need to keep up with the technical advances that organised crime has been developing. So in addition to updating certain existing offences that are facilitated by the internet, including child sexual exploitation, Bill C46 proposes to create new production and preservation orders to address today's computer and telecommunications environment. Mr. Speaker, investigative powers must be tailored to modern technologies. Investigations may be compromised if they are not. In addition, these changes assist in ensuring that established privacy protections put in place to protect the rights of all Canadians are maintained in the face of these ever-developing new technologies. Mr. Speaker, Bill C46 would update the existing dial number recorder warrant, which currently allows police to obtain data relating to dial telephone numbers. The proposed transmission data recorder warrant would allow police to obtain data in relation to the routing of an electronic communication, including communications by email or by cell phone in real time. Police would also be able to obtain historical data of the same kind under such a production order, Mr. Speaker. The existing requirements for obtaining dial telephone number data would continue to apply to the data obtained under the transmission data warrant. As with the existing warrant, the updated powers would explicitly exclude access to the content of the message. Mr. Speaker, the existing tracking warrant would similarly be updated to provide for both a production order for tracking data and a warrant for the real-time collection of that tracking data. These updates would create a two-warrant system which would better recognize the different expectations of privacy that persons live in relation to their personal location and that of their vehicles, transactions, and other things. Mr. Speaker, computer data by its very nature is volatile. As a result, there is a risk that it will be lost in the time that it takes for police to get a warrant or order to obtain that type of evidence. Police need a way to ensure that computer data necessary to an investigation is preserved during this time and during the fullness of their investigation. So the new preservation demand and preservation order is simply a do not delete order, requiring that the custodian of the computer data to ensure its preservation for a limited period of time and of specific data related to a specific communication or to a specific subscriber. This data will only be preserved for the purpose of conducting a specific investigation. It is crucial to understand, Mr. Speaker, that any disclosure of information under all of these legislative proposals would be pursuant to judicial authorization. That protection is not being changed by these amendments to the Criminal Code. We need to ensure that pursuant to a judge's order, investigators can obtain the kind of information they need, but no more and nothing else. We must ensure that any intrusion into privacy only goes as far as is necessary. These new measures guarantee privacy with precision and strike the appropriate balance, I submit, between law enforcement needs and privacy protections. The proposed legislative amendments are required to meet our domestic imperatives. However, they would also allow Canada to ratify the Council of Europe Convention on Cybercrime and its additional protocol on xenophobia and racism. So in this international context, this treaty is not only one of its kind, and it will allow Canadian law enforcement to avail itself of the international cooperation that the protocol permits. I can assure you, Mr. Speaker, that the legislative proposals put forward in this bill would not only contribute to getting Canadian law enforcement the tools they need in the 21st century, but they also demonstrate Canada's commitment to cross-border and hemispheric security in the Americas and assist in meeting international expectations for Canadian participation in the global fight against cybercrime. Mr. Speaker, lawful access is not about eavesdropping on private communication or monitoring the web and surfing emailing habits of ordinary Canadians. It is about ensuring that law enforcement and national security agencies have the technical and legal ability to keep up with new developments in information and communications technology. New technology is a useful and powerful tool. However, in the hands of criminals and terrorists and organized crime, this same technology can be used in ways that threaten public safety and national security. That is why the Government of Canada is committed to updating Canada's laws to keep pace with these ever-emerging technologies. While Canada was one of the first countries to enact criminal laws in the areas of computer crime, there have been no substantial amendments since the 1990s. Technology has evolved considerably since then, and Canada's laws have to keep pace. These increasingly complex technologies are challenging conventional investigative methods, and criminals are taking advantage of this situation, using sophisticated technology to help them carry out their illicit activities that threaten the safety and security of Canadians. So to overcome these challenges, legislative tools such as this bill and amendments to the Criminal Code must evolve so that law enforcement can effectively investigate criminal activities while ensuring that Canadians' privacy and civil liberties are always respected. So the proposed legislation will update certain existing criminal code offences and investigative powers, as well as create new powers to meet the demands of today's technological cybercrime environment. The proposed legislation will accomplish 5 things. It will update the current criminal code provisions to allow police to obtain transmission data, also known as traffic data, that is received or sent via the telephone or the internet. Secondly, it will require telecommunication service providers to preserve for a limited period of time data related to a specific communication or subscriber if that information is needed for an investigation of offense. Third, it makes it a specific offense for 2 or more persons to agree to arrange to commit an offense against a child by means of telecommunication. Fourthly, it modernizes the current tracking warrant provisions to better recognize Canadians' expectations of privacy. And finally, it updates the Mutual Legal Assistance in Criminal Matters Act so that the proposed new investigative powers in the Criminal Code are accessible to Canada's treaty partners. This bill deals with data preservation, Mr. Speaker, not data retention. When requested to do so through a preservation order, ISPs would only be required to preserve specific data already in their possession with respect to a particular suspect. Data preservation would ensure that volatile information vital to an investigation is not deleted before the police are in a position to access the specific data by way of a judicially authorized search warrant or production order. These proposed amendments would not require ISPs to retain data relating to all of their customers' internet activities. Privacy will be protected by these amendments. The government is strongly committed to maintaining the rule of law in all of its legislation. None of the lawful access tools, such as production orders or preservation orders or interception orders and search warrants, can be obtained in the absence of lawful authority. A person's reasonable expectation of privacy will continue to guide how the Canadian government operates and how its legislation will be enforced. In addition, the government will ensure that such authority will continue to be exercised, bearing in mind privacy and human rights contained in the Canadian Charter of Rights and Freedoms and the Personal Information Protection and Electronic Documents Act. The granting and issuance of warrants will continue to require judicial authorization. No lawful access, no production orders or preservation orders or interception orders or search warrants can be obtained in the absence of lawful authority, Mr. Speaker. So it is with a view to maintaining the privacy of Canadian citizens and keeping up with the sophistication of the new breed of high-tech criminals that I ask all honourable members to support C46. Thank you, Mr. Speaker.
Questions and comments? The honourable member from Elmwood Transcona.
Well, thank you.